I have been wanting to comment on this case since it started because so many individuals have speculated and created doubt. And one thing conservation officers, game wardens don't deal with, law enforcement shouldn't deal with, is speculation. We deal with facts and evidence. And that's what I want to share with you guys today, as this has just been one of those high profile poaching cases. And now the Attorney General of Ohio has come with some indictments. And for those of you that don't understand, I'm very familiar with the New Hampshire process, and it's very similar nationwide. So a grand jury is gathered and evidence is given to the grand jury, and then they come forth with a true bill or not, which is basically they indict the individuals. They listen to the evidence, they say whether you have enough evidence or not, or so to go forward. So the people actually carry the indictments after listening to the evidence. And that's exactly what happened in Ohio here. And this is the press release that I'm sharing with you today from Columbus, Ohio. Ohio Attorney General David Yost, on behalf of the Department of Natural Resources, announced the indictment of a Wilmington man accused of poaching an 18-point antlered white-tailed deer. He's quoted as, "Blinded by greed, the defendants set their sights on fame and fortune while disregarding basic hunting regulations," Yost said. "Instead of the cover of Field and Stream, their notoriety will be a booking photo." Just a great statement for an attorney general to say on a high-profile poaching case. The indictment returned this afternoon by a Clinton County grand jury accused Christopher J. Alexander of unlawfully harvesting the deer on November 9th, 2023. He claimed the animal had been on property owned by his sister, Christina M. Alexander, when he harvested the deer and presented written permission from his sister to hunt on her land to a wildlife officer. An investigation by Ohio's DNR Division of Wildlife, however, revealed incriminating evidence to the contrary. And if you've been following this case, you have listened to all kinds of speculation from all kinds of people. And again, game wardens don't deal in speculation. We got to deal in facts and evidence. So, and it says incriminating evidence to the contrary. Wildlife officers discovered through warranted searches of cell phone data that Christopher Alexander had illegally hunted the trophy buck on private property about 10 miles from his sister's land, and learned that the written permission from his sister had he had presented to wildlife officers had been falsified after the deer was killed to mislead authorities. Evidence revealed Christopher Alexander staged the deer taking at his sister's property with the help of Corey Hunnert and his brother Zachary Hunnert to conceal the poaching. And again, a lot of people don't think about after the poaching is done, there's a lot of crimes that get committed through this. And one is concealing. You know, when people make fake kill sites, they're actually destroying evidence, they're creating evidence, all felonies. So, and people don't think about that after they think, you know, this is just a wildlife violation, but they are actually tampering with evidence, and that is generally a felony. So the investigation also found that Corey Hunter aided Christopher Alexander in poaching deer on multiple occasions. So not just this one, but multiple deer on multiple occasions, providing the crossbow used to hunt and assisting in deer retrieval and staging with Zachary Hunnert. Christina Alexander is accused of falsifying the date when the written permission to hunt occurred. So again, his sister gave him permission, and apparently she falsified the document saying that he had, again, trying to cover up this crime. So saying that he had permission to hunt her property during that time frame, even though it wasn't killed on her property. Likewise, officers learned that Christopher Alexander's deceptively profited from illegal deer taking. selling deer antlers and receiving payments totaling $20,000 from an antler collector, a hunting magazine, and a company that sells deer products. So this is not just about this one exceptional white-tailed deer. This is about other deer. So it's just not about this incredible buck. It's about selling deer antlers. It's about making money. And whenever money is made in wildlife, there is usually violations. Uh, so like this deer stands out as the largest typical white deer in Ohio, showcasing remarkable antler uniformity. Additionally, some reports rank this as the third largest typical white-tailed deer in North America. Again, an extremely incredible animal that was harvested or poached, stolen from somebody that could have harvested that legally and had this as a huge achievement if it had been taken legally. So if you're a hunter out there and you legally hunt, guess what? That deer was taken from you. That was stolen from you. So don't think that poaching is okay. Poaching is stealing from the guys that do it right. And I just want to continue reading this. This once-in-a-lifetime deer embodies a great natural resource Ohio has to offer, Yost added. It is shameful that this deer ended up as in the evidence room rather than adoring an ethical hunter's wall as a prize trophy. So the Attorney General feels the same way I do, which is great. And he sees that deer that was stolen from the hunters of Ohio. And unfortunately, again, it's going to end up in an evidence room. Christopher Alexander, 28 of Wilmington, faces 23 total charges. And remember, when they charge, the Attorney General is looking at the laws, and he's looking at the elements of the laws, and he's looking what he has to prove. And he's not going to bring charges that he cannot prove. I will tell you that as a former prosecutor. It just doesn't make any sense to bring charges that you can't prove. You have to prove these in a court of law. So all 23 charges that he has, that Attorney General has lined up and knows he can prove this. 5 counts each of illegally hunting deer without written permission and taking possession of a deer in a violation of a division rule. So that's a regulation that the Ohio DNR has. 3 counts of theft by deception. Again, stealing something and deceiving people. 2 counts each of hunting without a license, hunting deer without a valid permit, and tampering with evidence. And again, that's usually when you start tampering with evidence, that is generally a felony. 1 count each of jacklighting, that is night hunting, that is using some sort of light source to take deer after dark when they're weak and they're vulnerable, theft, falsification, and the sale of whitetail parts. Corey Hunter, 29 of Hillsborough, faces 8 charges, 4 counts of aiding a wildlife offender, 2 counts of hunting without permission, 1 count each of tampering with evidence and falsification. Christina Alexander, 37 of Blanchester, faces 1 count of falsification and 1 count of aiding a wildlife offender. And Zachary Hunnard, 31 of Lebanon, faces 2 misdemeanor counts of aiding a wildlife offender. The white-tailed deer is widely recognized as one of Ohio's most prominent wildlife species and the state's only big game animal. It's historically important to Ohio is evidence, with the General Assembly declaring it as Ohio's state mammal in 1988. The cases are being prosecuted by the attorneys from Yost's Environmental Enforcement Section. Indictments merely contain allegations, and the defendants are presumed innocent unless proved guilty in a court of law. So this is the first step of the process, is getting indictments. So, and I'll explain it to you. So there's a grand jury, and the Attorney General or is one of the people from his office presents this to the grand jury, and they decide whether they have enough evidence to go forward. And then they bring a true bill forward, and then they go from there. So this isn't just, the game wardens driving this down. This is people like you and me that are sitting on this, uh, sitting here listening to this evidence as a grand jury and then giving a true bill to continue going forward with charges to go to the court of law. Now the process will start as they go to maybe a trial, or I'm sure the defense attorney will sit down and maybe work a deal. Because I will tell you, 90% of the cases, and it's probably even higher than that, it's probably 95, 98 cases don't make it to a trial. They will negotiate, they will come up with a deal, and then they'll figure it out from there. But 23 charges, that's a lot of charges to start with. And again, the Attorney General believes he can prove every one of those. And I have been listening to speculation all across social media and the running of the DNR officers, the game wardens through the mud, the agency. And this is so refreshing because this is based on evidence and it's based on other people's opinion. And generally, game wardens or prosecutors don't give their opinions until this. And even after this, I mean, this was a great statement by the Attorney General of Ohio to put this out to start this process. And again, it's just a process before the trial. But to make this statement, to get out there, generally we were all quiet until this point. And once I saw the evidence, I wanted to comment on this. I wanted to engage in all the falsehoods that have been thrown around and have been deceived. You have been deceived by other people in allegations, in speculation. And this is where the evidence started. That grand jury heard the evidence and then brought a true bill forward on 23 charges. So that's going to just start this process. And I just wanted to share that with you because I want you to see the evidence or the truth and share that, because why would we bring cases forward that we don't think we can prove? It is a waste of our time. It is a waste of the public's time. It's a waste of everything. But in order to get all this evidence, it is a complicated collection. And then it is organized. And then it is brought to the Attorney General or his liaison. It's usually an assistant attorney general, probably, and presented to them. And then they say, geez, you got a lot here. You have something. Let me bring this to the grand jury and we will get indictments. And that is where we are currently in the Christopher Alexander case and that poached illegal deer. That, again, these are not proven yet. It hasn't gone to a court of law, but this is certainly part of the beginning of the public record and want to get that out to you. So thank you from Warden's Watch. As a former game warden, as a former prosecutor, this is a great step forward. And I'll look forward to seeing how this case is resolved. But my guess is it'll be resolved, not in the trial, because as a defense attorney, I don't know if I'd want to put my client in that position. So, he generally, when you negotiate a case, you know what you're going to get. Sometimes when you get in front of a judge or a jury, you don't know what the outcome is. There could be people that get very angry about the poaching of deer, that really like deer, that really like wildlife. So sometimes that's a chance that a defense attorney isn't willing to take to put his client in front of. So there's a lot of things that are going on here, and I will try to keep you up to date as this goes on. But I certainly wanted to share this with you. And yes, this is a press release directly from the Attorney General of Ohio, that Dave Joyce, Ohio Attorney General, and I wanted to read that and share that because it's really important for you guys to understand what goes on with these processes. It's just not writing a ticket. When it becomes a big case like this, it takes time. And you can speculate all you want, but you really got to get to this point and let the evidence speak for itself. And that's where we're going. So we're going to let the evidence speak for itself. Thank you again from the Warden's Watch podcast.